Okay, folks. Welcome back after what I still call tea. And it reminds me of when I was the Stockton chair here. I was doing a tour of Boston one day, and our guide said, well, normally we would go at this point to visit the Museum of the Boston Tea Party. But unfortunately we can't today, because last night it was struck by lightning, to which a voice remarkably similar to the one you're hearing now said, "And who said God wasn't an Englishman?" On that point, I think I will now hand over to Nils Melzer to complete the set of panelists. Thank you, Nils.
Thank you, Charles. It's good to know where God sits. I'm glad to sit on his right hand. Or is it the left? I have to claim hors de combat status. I have flown in from Tokyo yesterday, or was it today, or the day before yesterday? I don't know what time and what day it is. But no, thank you very much for the invitation to speak on this panel. And thank you very much indeed to the other panelists for the really thoughtful and valuable contributions. I think it is great not to be, as I've done for a long time now, just in the role of presenting the interpretive guidance and then gathering a few comments, but actually being able to listen to opinions that have been constructed and developed over some time now that this booklet has been published. And it really shows that there is a discussion that has to be taken further. Clearly, civilian participation in hostilities is an extremely difficult issue, as we all know. It raises extremely difficult practical and legal questions, and I think we all need to show a degree of modesty in dealing with this and being aware that a booklet like this cannot be perfect. It can at best be a first step in the right direction. I'm glad some of you kindly think that it was. And clearly it will generate some disagreement, some concerns, and a lot of discussion. And I think if it does so and it leads to a more consolidated, comprehensive consensus at some point, then it has more than served its purpose. So what I'd like to do is simply perhaps respond to a few points I heard from the previous contributions without going into kind of a defense of the interpretive guidance. I think this is not really the point. I think we should actually go further, go beyond that. Nevertheless, I have to, in brackets, just to say that although I'm here for the ICRC, obviously I do not necessarily, not everything I say is an official position of the ICRC. It's my personal opinion and my private capacity. First on the section 9, Ryan's contribution and comments, I found extremely useful. I think when he said that it is perhaps a leap forward, the lex ferenda, if I understood correctly, so it doesn't necessarily represent the lex lata, and that perhaps, although he also sees strengths, the weaknesses would be that it is not sufficiently based in specific treaty provisions and is not based on preceding state practice. I think he is to a certain extent obviously right. I mean, obviously we are of the opinion that there are specific treaty prohibitions, like the prohibition of means and methods of a nature to cause unnecessary suffering and superfluous injury, and the general principles of military necessity and humanity informing all of IHL, or law of armed conflict, as people not in Europe used to call that body of the law. But I think one of the reasons we call this an interpretive guidance is that this is not a customary law study. It is not a recount of treaty law. It takes an existing treaty and customary provision and tries to put some meat on the bone, to actually interpret the law. It is a question much more of treaty interpretation and interpretation of the law than claiming that every word in this guidance is actually reflects existing lex lata and customary law. I think the quality of the booklet will depend on whether the interpretation is a reasonable one according to the existing treaty rules of treaty interpretation. So that point being made that it is really about interpretation, it also, let me see, the next point is, one point I thought was really interesting is the hors de combat argument. It has been discussed, at least internally. It wasn't a big point of discussion in the expert meetings, but internally in the ICRC we have discussed this as an aspect. But I think what we should recall is that section 9 of the interpretive guidance is in the chapter on discussing the modalities that govern loss of protection. And we do not claim that someone who is a legitimate military target becomes somehow protected against direct attack or is no longer a legitimate target if it is not necessary to kill him. We simply say that against legitimate military targets, there may be certain restraints in the kind and degree of force that can be used against them, even though they remain legitimate targets formally. Perhaps not in all situations lethal force would be warranted. While obviously if you make the argument that such a person is already hors de combat, then it would be unlawful to target that person because he's no longer a legitimate target, and it would also be a war crime to target that person. Excessive use of force against a legitimate target, excessive by reference to what is actually necessary in the circumstances, is certainly not a war crime. It is not criminalized, and also shows that although perhaps the individual soldier determining how much force is necessary has obligations under IHL, he would not be committing a war crime if he uses more force than is necessary. So the reason we are not discussing this in terms of hors de combat is because we're presuming that we're looking at legitimate military targets, and persons hors de combat obviously would not be legitimate targets. On Blaise's comments on organized armed groups and who is, this obviously, it refers, as he rightly said, to this very difficult question of who is today in armed conflicts actually the enemy, who is a member of an organized armed group, and the necessity of maintaining the rule of law in the law of targeting in today's battlefields and the extreme challenges that that poses. I would say the first requirement of the rule of law is certainly clarity of standards, to avoid arbitrary and erroneous use of force, to kind of establish a standard that can be respected in practice by the practitioners on the ground. And it is true that no one in his right mind would hand this booklet to a foot soldier and tell him, look now, you just, every time you want to decide on the use of force, you'll read through this booklet and you will surely find the answer if you're lucky, as long as you're alive. I don't think this is really a realistic standard, obviously. These are not rules of engagement, and I don't think the ICRC is very good at drafting rules of engagement, and we didn't attempt to do so. I think we tried to clarify the law from our perspective, and we hope that we could provide a set of concepts that would make sense as a basis for legal advisors to the armed forces, so that based upon these and informed by these concepts, they could come up with rules of engagement for each situation. It is not a training manual either, because depending on what kind of forces one is training, clearly such instruments have to be drafted in different ways, and this again is not really the strong point of the ICRC. In that sense, I think that what this is much more in the tradition, if you will, of the commentaries to the Geneva Conventions. Here it's basically a commentary on a treaty and customary rule that we drafted, informed by and based on also the discussions with the experts in a period of 6 years. Clearly, combat function can be defined more narrowly than we did. It can be defined more generously than we did. I think we did try to, as much as possible, as reasonably possible with non-state actors, find some kind of an analogy to the state armed forces. Now that is very, very difficult when state armed forces and membership therein when that's formally regulated in national law. You cannot have the same kind of formal concept of memberships in irregularly constituted armed groups. Clearly, for all that matters, it's illegal to be a member of an organized armed group. National law is not going to regulate membership. This is certainly a de facto notion. It is simply a person who at some point took up weapons and got into an organization and started fighting for a non-state belligerent. Now, how do you phrase that? That is a huge challenge, and I don't claim that continuous combat function is necessarily the best formulation. I think we just couldn't come up with anything better. We felt that it corresponds best to what, in a generic sense, combatancy is about targeting. It's really the fighter. And I do think if we look at support functions, if you have logistic personnel of the armed forces, they are trained and they are armed to fight, even though their main function is not to fight. At least in the Swiss armed forces it would be like that. I know the Swiss armed forces never fight, but just in case. I know you also talked about Bob the truck driver, and I know only those who were part of the expert process know that from the 5th year, when he sensed that sometimes he might be a target, he changed his job and he became a cook for an organized armed group, because somehow he felt safer that way. Now, in the Swiss armed forces, even cooks are armed and trained to fight. If their kitchen should be attacked, they are expected to participate in the hostilities, and I would say the same should apply for organized armed groups. If they went through a combatant training and are issued some kind of a weapon, I would say they have something like a residual or dormant or combat function. It is much more what we're trying to distinguish here is the fighting forces from the civilians accompanying them. This is much more difficult with irregular armed groups than with regular armed forces, where you have the contractors cooking for them, and perhaps the regular member of the regular armed forces who is cooking, but who also has this right to directly participate in hostilities. For irregular forces, we cannot speak of the for non-state forces we cannot speak of the right, but we can speak of the function to directly participate in hostilities. So again, it is obviously very difficult in practice, but it was a good faith attempt to try to come up with concepts that are as similar as possible to the regular armed forces. The revolving door of protection obviously is a difficult issue. I think we can agree or disagree about what the law says. I think it is true that it is the formulation for such time indicates that it is linked to an activity. It is not a status-based targeting. So that activity can start and it can end, and it is not something like joining a group that makes you, obviously that does make you a target. In our view, it makes you a non-civilian, actually losing civilian status. But if you are a civilian, you're not a member of a group, then it is the activity and the beginning of that activity and the end of activity that leads to loss, or that defines loss of protection. In our view, it relates to individual operations. I know not everyone agrees with that. But the point I want to make is that this farmer by day and fighter by night, in our view, is a constant target. It is almost inconceivable, I would say, in practice that you have someone who is a farmer by day and a fighter by night for any period who is not an organized armed actor. I mean, in practice, maybe someone can teach me otherwise, but I have never heard of a case where someone actually had this kind of systematic pattern of participating in hostilities without being somehow affiliated to an armed group, getting supplied or trained or coordinated by an organized armed group. And these loose structures can already constitute a continuous combat function. I think it is much more, but you may have perhaps teenagers in, let's say, non-international armed conflicts or occupied territories or whatever, who take every opportunity to throw Molotov cocktails at army patrols or something like that. There you might have persistent participation or recurrent participation in hostilities, but in our view this is a clear case where in the interval between such operations, law enforcement standards are more appropriate to counter these kinds of behavior than targeting under the law of conduct of hostilities. And then finally, on the Françoise's remarks on the interoperability of IHL and human rights law. Now here we go, in a sense, a bit beyond what we addressed in the interpretive guidance, because at least we said we dealt exclusively with our view and our interpretation of international humanitarian law and did not address human rights law. But it is obviously linked to and related to what we're saying, because it is the issue of use of force and targeting in situations of armed conflict, perhaps below the threshold of AP2, additional protocol 2, but already armed conflict, because Article 3 common applies. Obviously, on the framework you proposed for international armed conflicts, I don't think there's any disagreement here. For non-international armed conflicts, you proposed that Article 3 common situations do not amount to AP2, to the AP2 threshold, that there the use of force and targeting should be governed by the law enforcement paradigm of human rights law. And I just ask myself whether that really is a solution. When you distinguish between Article 3 common threshold and AP2 threshold, would that now guarantee, if you apply law enforcement standards in all non-international armed conflicts that do not reach the level of AP2, and we might let aside for the moment the territorial control question, but does that guarantee appropriate use of force? I don't really think so. I think you still have, if you take the Colombian context, at least a few years ago, when the FARC was still controlling territory, or the Sri Lankan context before the end of the war, and you might have a military commander of the rebel group that crosses into government-controlled territory, the capital, to visit family members or whatever, so without weapons and in civilian disguise. That person would still be a legitimate military target because he is a military commander. AP2 applies, at least the standard, the threshold would be reached. That person is now in government-controlled territory, unarmed. Now, under your approach, he could be shot to kill. And while I think under our approach that we are proposing in interpretive guidance, it is a question much more of the military necessity and unnecessary suffering that would limit the use of force against that person. I also think that whether the Hague Law applies or not should much more depend on are we in a situation of hostilities or not, because the Hague Law essentially governs the conduct of hostilities in all armed conflicts. Armed conflicts, after all, at least non-international armed conflicts, require armed confrontations of a certain intensity and protraction or duration. And so we do have the conduct of hostilities, and the law, the Hague Law, or the law of conduct of hostilities, is specifically developed to regulate the conduct of hostilities. So I do think that it is necessary to allow for that framework to exist also below the threshold of additional protocol 2, and that in all armed conflicts, in situations of conduct of hostilities, Hague Law applies, but outside of conduct of hostilities, whether you're in international or non-international armed conflict, AP2 or below that threshold, it is law enforcement standards that apply. That's the Geneva Law, that's exercise of authority over the civilian population, over prisoners and others in the hands of a party to the conflict. That's, in fact, the paradigm of law enforcement. It depends on the circumstances, not in the conduct of hostilities. Perhaps to just one point that was made as well, that at least I gathered from your remarks, Françoise, that you said the interpretive guidance moves from a pre-existing notion of activity, 100% activity-based DPH interpretation, to a kind of a divided approach where part of it we create a new category of status of these non-state armed groups. Just here to clarify that, I understand obviously your argument. We are not of the position of the opinion that we're creating a new category, but we much more think that we clarified that category is implicitly existent in the law and in law of armed conflict and in state practice in non-international armed conflicts. No state in a non-international armed conflict above or below AP2 threshold would hesitate, I would say, to attack a rebel while he's having his lunch. He's not treating him as a civilian who is protected in the interval between military operations. But then just to conclude, perhaps, the argument that applicability of conduct of hostilities rules in non-international armed conflicts below the threshold of AP2 aggravates the conflicts or does not facilitate a political solution may be correct. I don't express any opinion on that. I just feel that this is not a strictly legal argument. It is much more an argument, should the law apply or should it not? But if we look at it as it exists, I think it just does apply, and whether that's a good thing or a bad thing is a different question. I do think that the limitation of the applicability of the law of conduct of hostilities to AP2 situations does raise serious questions as to obligations of non-state actors, at least from the perspective of the ICRC. In practice, in all armed conflicts, we do think that it's extremely important to engage both parties. And we have today almost exclusively non-international armed conflicts where at least one party by definition is a non-state belligerent. And if in most armed conflicts of such a nature we are below the threshold of AP2. So if we have to tell these people, well, you don't have any obligations under the Hague Law and the conduct of hostilities, and we can't tell them that they have human rights obligations because they're non-state actors, then what do we tell them? I do think it is in practice extremely important in armed conflicts that we can make the argument, look, you're a belligerent, and that's why you have certain obligations just as your enemy has. And in that sense, I think there's a reason why in armed conflicts both parties have such obligations, and we should not have this state-based perspective of simply of a law enforcement paradigm that we cannot transmit or transpose to non-state actors. But these are just a few points of clarification as to how I view these arguments, but I'm very grateful for that discussion, and I hope we still have time also to open for questions by all of you. Thank you very much.
Thank you very much, Nils. I've been asked to finish at about 4:20, so I make it we've got about 20-odd minutes for questions. So I will now open the floor, and I know Wolf has already asked for the floor.
Well, thank you. Many would congratulate Professor Goodman for his very balanced presentation. I don't. It was either a ruse of war or it was an act of lawfare. I may say that you are either deliberately or involuntarily either confusing limitations with prohibitions, or you are clearly misinterpreting the underlying concepts. Let me make clear what I mean. First of all, you refer to a Colombian manual. Now, if you know the drafting history of the Colombian manual, then you should be aware that this is due to the very hybrid situation in which the Colombian government found itself. A mixture of freedom fighters or alleged freedom fighters, organized crime, and even organized crime groups, sometimes becoming parties to a non-international armed conflict and sometimes only pursuing their criminal aims. And so this is far from being a piece of evidence. And especially with regard to what you said with a view to killing enemy combatants, where you try to introduce a principle of proportionality, I was thinking, wow, you must be German. Now listen, how can that be? If the law of armed conflict prohibits collateral damage amongst civilians and civilian objects only and insofar as that damage is excessive, to the military advantage anticipated, how then can the killing of an enemy combatant be unlawful because it is violating the principle of proportionality? That is absurd. Moreover, the principle of chivalry. God, this gives me a shiver. Where do you take that from? A principle of law? This is, again, a contribution of mystifying the law of armed conflict by introducing some metaphysical concepts which simply don't exist in the law. We had that argument already in the Kosovo campaign. I'm speaking 1999, where it was not only a question of accuracy when we had the air attacks from 15,000 feet, but also the alleged cowardness of the NATO forces. And fortunately, at that discussion, we all agreed this is not a question of law, whether you attack from 15,000 or 5,000 feet. Moreover, of course there is a prohibition of killing POWs who try to escape, but for the mere fact that they are hors de combat because they had fallen into the hands of the enemy. So this is not a question and nothing that you can relate to the alleged prohibition of killing an enemy combatant and rather to capture him. And look at the attacks on the Iraqi forces returning to Baghdad in 1991, where again there were allegations that the attacks on those returning forces were unlawful because they had gotten rid of their weapons and they only wanted to go home. But in those days we all agreed they were enemy combatants, and in view of that, an attack on those returning forces was well in accordance with the law of armed conflict. So 11 years later, we are again reopening that discussion and by introducing this very metaphysical principle of distinction. And how can you refer to Article 52, paragraph 2, the definition of military objectives, which is limited to objects, and apply that to human beings? Excuse me, this has no foundation in the law whatsoever. So
Ralph,
I must say...
I know Joram wants to get a word in edgeways as well at some stage.
Yeah, but the final sentence, Charles. What we are witnessing here is, again, an overall effort by, well, interpreting, I would say rather modifying, the law of armed conflict with a view to prevent war. And sorry, this is not the object and purpose of that very law. Thank you.
Thanks, Wolf. I'll take a couple more questions before I pass over to the panel. Joram, I know you had something.
Okay. Unfortunately, I was not here when the presentation by Goodman was made, but I want to associate myself 100% with Wolf's comments. I hope that it's understood that under the lex lata, as distinct from any lex ferenda that one can think about, and which I resent anyhow, under the lex lata, you are allowed to kill enemy combatants in whatever number, wherever, whenever, and in whatever circumstances they happen to be, even if they are in the shower. And you are allowed to conduct war in such a fashion that you will have 0 casualties yourself, whereas 1 million enemy combatants will die. Proportionality applies only to the relationship between enemy combatants and enemy civilians, period. This is only in corroboration of the point made by Wolf. But actually I took the floor in order to make a point about the presentation by Nils Melzer. Nils, and even earlier, mentioned that the interpretive guidance is a first step. I agree that it's a first step. However, he then added somewhat confusingly, as far as I'm concerned, the words "in the right direction." I think that it was a first step in the wrong direction. I want to remind him and everybody else here, including you, Charles, that most of the Western experts withdrew from the project by way of protest against this document that we regard in parts as totally objectionable and even abominable. And therefore, to now all of a sudden present it as if it is the product of work by experts is completely misleading. And I'll give you just two examples. The first was this, again, curious reference to hors de combat. What do you mean hors de combat? A civilian cannot be hors de combat. Only a combatant can be hors de combat. And therefore the question is whether a civilian who's who's directly participating in hostilities for such time as he is doing it has turned himself into a combatant. Then, should he become hors de combat by being wounded or by surrendering, he, of course, or she is entitled to be treated as such. But the big issue is such a person a combatant? And that is where we totally disagree with this doctrinaire approach of the ICRC. You asked rather rhetorically, Nils, where does the expression farmer by day, fighter by night come from? Let me enlighten you. It comes from the Yves Sandeau commentary on Protocol 1 additional to the Geneva Conventions. And it already appears in that, you can check it, it already appears there in inverted commas, because actually the locution was coined by Denise Binderschedler, a very distinguished member of the committee of the ICRC. But that was in an earlier era of the ICRC, when the ICRC was not as doctrinaire as it is today. Now, you are also asking, where do we find the phenomenon of a fighter by night and a farmer by day? Let me tell you, we encounter it all the time, on the good side, on the bad side. If you take World War II, at the time when the resistance in France actually developed into something which was a real hurdle for the Nazis, you had thousands of people like that, who during the day actually worked in whatever civilian capacity, and at night took out the rifle or the TNT and went out to derail a German train or otherwise to attack German soldiers or to save British and American pilots. Every day they were farmers or the equivalent thereof. They may have been working in industry, and every night they were fighting. The idea that such a person from 9 to 5 is a civilian, and then from midnight till 5 a.m. is a combatant is nonsense. And clearly there was continuity, and clearly all such persons had to be treated as combatants 24 hours 7. Because if this is what you want to do, namely to directly participate in hostilities, you have to pay the price. And the price is that if you are found as such, identified as such, you have become a combatant and can be killed. Forget about the issue of war criminals. Nobody's talking here about war criminals. We are talking here whether you are targetable. And the answer is absolutely yes, contrary to what it says here in your interpretative guidance. You are subject to being targeted 24/7. You raised the issue of the cook. This is my issue, I want to remind you. First we had the issue of Bob the driver, but we resolved that issue of Bob the driver. We did not resolve the issue of the cook. And you do not distinguish apparently between a cook and a caterer. I am not talking about a group of, an armed group of civilians directly participating in hostilities, buying foodstuffs here or there. I'm talking about a group that finds itself, let us say, in the jungles or in the mountains of Waziristan, and they include a cook. And my answer is yes, this cook is a civilian directly participating in hostilities, because he serves as a cook in that remote area, within that context, as actually a combatant, not as a regular civilian. Otherwise, the result will be absurd. You will have a commando unit, special forces, going into the fastness of Afghanistan mountains, and then I have to say, who's the cook here? Because he's exempt, I cannot attack him. I shoot to kill everybody there. And I don't care whether they are in uniform or not. I don't care whether they are singing at the time some songs or even hymns. They have become members of an armed group, hence they are combatants, as long as they do not surrender as long as they are not hors de combat. They are targetable at all times and under all circumstances.
For those of you who were not party to the experts' meetings, you can now guess what they were like. And some of us actually... Some of us actually debated whether actually taking part in the sessions made us directly participating in hostilities. I will now, or maybe we were an armed group, I'm not sure, but we'll now give the panel the opportunity to respond. Ryan, I'll give you first go.
So I suppose the irony is that I also associate myself with Wolf's comments. And I'll take it upon myself to say, maybe I wasn't clear about this, but I was also using the Columbia Manual to criticize it. I was suggesting it wasn't a form of support. On proportionality, I was saying the Israeli Supreme Court injected a proportionality analysis, but the IG is a categorical prohibition such that if there's even one loss or risk of loss to one soldier on the attacking force's side versus the enemy, that's already sufficient to meet the necessity standard. That would be necessary to protect that one, the risk to the one individual. So we're in complete accord. Maybe I would say something more about the Columbia Manual, and you're right, I don't know as much in the details, but I'd say something about its consistency with the IG after the IG was written, but that's also still bootstrapping by using it. So the Kuwait-Iraq scenario of the retreating forces, I don't think anything I said would change that debate or the outcome. So if it's a force that's retreating and regrouping, they're not in the context in which I was describing. The fleeing POW, and I hope it doesn't seem as though I'm retreating from my positions, because I still think these were my positions. The fleeing POW, that's why I put that in the category of the general structure. It was not directly relevant or specific support for it, but it's only in the general structure in that it shares some of the intuitions, I think, that we might have about a combatant who then flees and is now no longer within the control. And we can debate about that. Maybe we do have a difference of opinion about that intuition. And the last one, in part, on the chivalry, I didn't think that was doing as much work, and maybe we also do disagree there, in that I just think, by that I mean the same principle of humanity that informs superfluous injury and unnecessary suffering. Not chivalry, once again, back into some kind of proportionality analysis, as though the attacking force would take risks or internalize the risk on itself in order to protect the enemy or the adversary. So that's maybe where chivalry would come in which we once again might be on the exact same page with respect to the categorical versus the proportional. And like I said, I can take it upon myself to say that maybe I wasn't clear enough about that, but so I associate myself with Jorm's comment.
Nils, over to you.
Yes, thank you. I don't have that much to say. I mean, just on the escaping prisoner of war, I mean, let's just recall that a prisoner of war is hors de combat, but if you're hors de combat and you're trying to escape, you become a legitimate target. So the escaping prisoner of war is a legitimate target, and the restriction on the use of force against that legitimate target is an interesting case. I agree, we're in the transition between someone who is hors de combat, who then loses protection, but I think it is an interesting point. It's not something you can just, wipe off the table. It is a norm in Treaty IHL that does restrict the use of deadly force against someone who has arguably already lost protection and is a legitimate target. But okay, I mean, we're in a transition period there, and I think also as Section 9 generally would only be relevant in practice in such kind of extreme situations and not in open combat. The other point is, I think I perhaps didn't express myself well with regard to the fighter by night and the farmer by day. I said the interpretive guidance does say that he is a legitimate target, that it is necessary to interpret IHL as stripping organized non-state actors of their protection continuously, precisely because we want to avoid that particular pattern of behavior of farmer by day and fighter by night. And the point I wanted to make is that in practice, obviously it does exist in great numbers, but if you're a member of the resistance, that's exactly the point. You're part of a resistance group, loosely organized as they may be, but you're still part of an organized resistance, and that's why you're a legitimate target at all times. It was more with regard to individuals who on their own spontaneously sometimes happen to participate repeatedly, that there we think there is the revolving door. But anyway, I think that's all I have to say. Thank you.
Do either of the other two wish to add anything? Yep, Françoise.
I'd like to respond to some of the points that Nils made. First of all, in the example of Colombia and Sri Lanka, the question would be whether it was an AP2 conflict. If it was an AP2 conflict, then do remember that I suggested that in NIACS, not IACS, that there may be a territorial limitation of the applicability of LOAC to those areas where the fighting's happening. So if you've got a military commander who has been fighting in one area, then he goes to another area where there is no fighting going on, then LOAC would not be applicable, so you'd be using a law and order paradigm, except in relation to grounds of detention. If it weren't AP2 and it was only Common Article 3, then it would be a law and order paradigm, so it would be a matter of seeking to detain him, so I don't think there was a problem there. You said that Hague law should be applied across the threshold of Common Article 3 because it's been specifically designed for that. I'm sorry, I disagree. The evidence of specific design is that which is in treaty law. The treaty law only has any Hague-type provisions across the threshold of Common Article 2. Treaty law does not have any Hague law provisions across the threshold of Common Article 3. So the only evidence for the possibility of Hague-type rules across the threshold of Common Article 3 is customary law. The main source is the ICRC customary study, which is not uncontroversial, and the Rome Statute. But if you look at the Rome Statute, the provisions that apply in NIACS are basically breaches of Geneva law plus breaches of what would be AP2 rules. They don't extend it more widely than the very limited concept of Hague rules that you find in AP2. So I don't think it's the case that it's clearly established that Hague rules apply across the threshold of Common Article 3. Thank you.
I think we've got time for one more question.
I'm Dan Cocolette. I'm from the People's Republic of Cambridge, which is a nominal ally of the United States. And I will disclose that I was a colleague of Professor Goodman for a short time. I did think I heard one of the accusations against his work as a covert effort to prevent war. I understand what the point was about, but a very large amount of the public support in this country for our excellent armed forces is because we believe they do, in the end, prevent war. And I think that one of the obvious virtues of what we're hearing about today is that a clear and practical system of war law is going to prevent war. I don't think that's a criticism. I think that's a virtue.
Thank you. Blaise, could I just ask you for a comment on that as a practitioner?
A political comment? I've got to get my appointment out again. Well, yes. I mean, obviously, in the greatest sense of the word, we would all like to stay home and theoretically put down the arms and say peace is broken out. But, you know, the realities are, even for a country like Canada, which many perceive, particularly south of the border, as a peacekeeping country, which denies our history, I think, very interestingly. You know, even Canada acknowledges that the realities of the world is you need a well-trained, well-equipped, flexible, capable, operational combat force to do not only war fighting, but peacekeeping and peace enforcement operations. So yes, ideally, we'd all like to prevent it and go home and I can watch the Dallas Cowboys all day long on the NFL Network. But seriously, that's just not the world we live in. So when we do go, we have to. I agree for 100%. As purpose of the law, as Nils has indicated, is clarity, and And that's what forums like this are trying to offer, I think, the opportunity to clarify for all of us, but importantly for those who have to advise those who actually pull triggers.
Thank you. That's a wonderful way to finish. I was once told that the armed forces are the only people who are trying to do themselves out of a job. And I think that's a good way of summing it up. Now, I'd like to thank all the panelists very much for what I think has been a very interesting afternoon. Dennis, over to you.
Folks, we stopped the luncheon presentation about 10 minutes early, and Charles has stopped this one at 10 minutes early. Several people indicated they had questions for Bobby Chesney concerning his luncheon presentation, so we wanted to take 10 minutes now to see if anybody would like to raise those. Dick Jackson, Bobby, you take this.
Bobby, what I wanted to ask you was an implication in your article with Ben Wittes and a point made in Al-Bahani is that there ought to be or needs to be some legislation to sort out this mess that you've described of law being created by individual judges in individual cases. Do you know of any efforts along those lines, and what are your views about how helpful that would be towards resolving at least the long-term detention problem?
Yeah, great question, Dick. So the larger report, whereas the lunch presentation was focused on the debate over the substantive scope of detention authority, the larger report spends a considerably greater amount of time going over the evidentiary and procedural issues that the judges have been smoothing out in the process and pointing out ambiguities on things such as the voluntariness standard and other important matters. We try to make clear in the report that our personal preference is that there would be domestic legislation to smooth out these matters. As to whether it's going to happen, well, there have been reports in the media that Senator Graham and others have possibly got something in the works. We'll see if anything like that ever emerges. I think that the way the media was reporting things, there was a lot of talk as recently as about a month ago that maybe something significant would be introduced with some degree of White House cooperation, but this all seemed to get hung up on other issues unrelated to national security and foreign affairs. So I don't know whether we're ever going to see anything about this, especially as election season gets closer. And I want to make clear that neither Ben nor I nor our co-author Rabia were meaning to suggest that the district judges are doing a terrible job or an inappropriate job. We just think it's a situation in which the elected branches have a responsibility to step forward and say more clearly what they think the rules ought to be. Yes, ma'am. Gotta hold it down.
Okay. You were saying, as far as I understand, that the Court of Appeal is again going to adopting a position where the laws of armed conflict and international law is less relevant than the internal domestic U.S. law with regards to the detainees. But what is the position of the government, of those representing the government in these proceedings? Do they also continue to rely mainly on domestic law, or has there been a shift towards more reliance on laws of armed conflict?
The Obama administration made very clear in its March 13th, 2009 filing in the habeas cases that it believes the law of armed conflict informs and constrains the president's detention authority. And they made a point of saying it very, very expressly. The controlling rule from the D.C. Circuit Court of Appeals, which is the current governing rule in these cases, it's the Al-Bahani decision, very clearly says no international law has any relevance whatsoever to any of these determinations, and that it is entirely a function of domestic law. It's a pretty controversial position to stake out, to say the least. Sir, Colonel.
Yes, I must say, if I can just take that point a bit further, even in our human rights-ridden liberal courts in Europe, there's at least an acknowledgement as the role of international law of armed conflict or international humanitarian law. I just find it breathtaking that that the U.S. Courts, albeit at a fairly low level and haven't had any, say, grown-up supervision yet, shall we say. We look forward to seeing if there are going to be any further appeals, although the 4-4 split, as you mentioned, may cause some problems. But I'm just quite flabbergasted, shall we say, at the complete absence of any consideration of those issues by your courts in that respect. And in fact, in some senses, is tantamount to the fact, and Françoise Hampson can speak of this, that the European Court of Human Rights never mentions the law of armed conflict either. And it's a cause of great frustration. And I guess the next aspect of that is anyone telling the judges what the law is, or are they just not interested?
So it's a mixed bag, and it's worth pointing out that, you know, if you'd asked a year or two ago, what do U.S. courts have to say about the relevance of the law of armed conflict in this situation relating to detention policy, the answer that would jump to mind is the Supreme Court's decision in Hamdi v. Rumsfeld, which in 2004 very clearly said that the laws of armed conflict inform the construction of the AUMF on this very issue. Now, that was a plurality decision, and I suppose that created the doctrinal wiggle room for the D.C. Circuit panel that I described earlier to very recently say in Al-Bahani something essentially dead opposite from that. This is the view of two Circuit Court of Appeals judges. It's the law of the circuit for now. If there is going to be an en banc review by the circuit, no doubt that will be part of what spurs the circuit to do it. It just so happens that given the particular person who's likely to be the next justice replacing Stevens, that the Supreme Court will be sidelined from this particular issue. Now, as to what's being said, what's being briefed? Are these types of arguments we've been having, or variations of them focused on detention policy, being put in a sophisticated fashion into the litigation documents themselves? Not nearly as much as it ought to be. It comes up, but as I described in my lunch remarks, for those who didn't hear it, when this case was briefed to when this issue was briefed to the Supreme Court in 2007 and 2008, resulting in the Boumediene decision, which didn't reach the question, the entire discussion of what the law of armed conflict has to say about detention policy was framed through the lens of DPH, which, to my lights, makes no sense. And so I think we should be concerned about the quality of the discussion or dialogue going on about LOAC as it relates to detention. Yes, we should be concerned. General.
Bobby, I think you're exactly right, although I do understand why you're surprised about that. The history, the tradition in our courts is that they really do stay out of those law of war or military discretion type decisions. And I think, and I don't know this was the thinking of the court, but if they get into that, then the tradition of the court is deference to the military authority. You know, you have a Goldman versus Weinberger type rationale where the evidence was overwhelming that there was not a physical reason. It was a yarmulke case that you could not wear a yarmulke, and the court basically says, doesn't matter because we're just going to give discretion to military authority. So in a sense, perhaps what the court is really doing is, in essence, retaining their options by looking at it in that particular mode. And the more you get into a military, a war-fighting mode, then there is the deference to military judgment as well as the elected branches of government.
The deference issue lurks in the background of a lot of these cases. The court's very strong on deference to the executive branch's factual judgments, predictive or retrospective, with respect to legal interpretation on areas of law that touch on military affairs, much less so. Harvey.
D.C. Court of Appeals is not one of our lower courts. I think significant numbers of justices have come recently from that particular court. But the second issue is, I think what the court is saying in the context is, when it comes to habeas, which is their interpretation of constitutional right, black letter constitutional law, they see that as trumping all other treaties or issues of that nature. I think that's what the court is saying, that in the context of habeas, they're not interested in the law of armed conflict because under our Constitution, they're going to take the case and they're going to look at it. That's a different sort of view than showing discretion to the military side of the house. It's saying this is our prerogative, and since the Supreme Court has made it clear in the previous case that they're going to assert their habeas right, I think the Court of Appeals is saying that's how we understand it.
Yeah, I think there's something to that. There's also a strong, these particular judges, the two judges involved in that panel opinion, are not big fans of the role of international law in domestic legal affairs generally, which has been sort of a recurring issue in our politics for the past 8 or 9 years.
I
Yes.
just say one thing? Now that I heard what Harvey said, he's right and I'm wrong. No, and I mean that in all seriousness. When you really think of the fundamental nature of habeas, I think that's what the court really is. I know, it's disturbing even to say it, but.
Dennis, should we cut off or go on? Sir, Neil, sure.
Jaak Rosari, Nord University. I want to take a little bit of a different tack. With reading the statistics of how many of the detainees that had been released have actually gone back to terrorism, I understand that that's a major concern why the government wouldn't want to release a lot of the people that it has detained. One of the issues under the last George Bush administration with the detention was that some of the detainees that were attempting to claim prisoner of war status and weren't given it because they didn't deserve it, the Geneva Conventions require that they be treated as POWs until a judicial determination is made. So a determination was finally made. My question is, why not take a different tact and be magnanimous and say, fine, you're all prisoners of war, which under the Geneva Conventions then would allow their detention without any specific cause until the end of the war, meaning the end of the war on terrorism, and you wouldn't need to release them at all.
It's a great question. I think that for the majority of these detainees we're talking about, their objection is not that they were denied POW status when they should have gotten it, but rather that they were not who the government says they were to begin with. They were innocent persons who shouldn't be detained, period. And the last thing they'd want to do is say, well, in fact, I was in fact a member of this organized armed group, and therefore, and if you'll just give me POW status, I will then be detainable. Their claim is I was on a humanitarian tour of Afghanistan, what have you, and should never have been grabbed in the first instance. Grabbed for a bounty, what have you, something like that. I'm standing between you and having a break before happy hour, and George.
I think another point on this PW business is the simple fact is if we declare them to be PWs, then do we not run into a conundrum with respect to our objections? Protocol 1, Article 1, I think 4.
So maybe, or to take it even back a step further, the common Article 2 threshold, except insofar as we're talking about fall 2001 in Afghanistan, and I guess up at least until the time of the Karzai administration taking office, the common Article 2 threshold that's a predicate to being able to talk about POWs in the first instance isn't crossed for everyone else. And so it's a small subset of persons who we could be having that dialogue and debate about in the first instance. I'm happy to talk about this more if anybody wants to talk about it over a beer at the happy hour.